Hello, everyone out there in podcast land. Welcome back to another episode of Adventure Capital, where we discuss the entrepreneurial journeys and adventures with founders who have raised capital on WeFunder. Huzzah! Today we have Elizabeth L. Carter, Esquire, LLC, a boutique law firm that assists small businesses, cooperatives, and nonprofits with the legal compliance of raising capital from both accredited and non-accredited investors. Elizabeth, you are appreciated. WeFunder gang, take it away.
Yeah, so I guess to kick it off, we're going to be talking about the new regulation crowdfunding law changes that are going into effect March 15th. We can go through a few of those, but first, Elizabeth, would love to just hear a little bit about your background and how you got involved with regulation crowdfunding specifically.
Yeah, for sure. So actually, my background is in community development law. I wanted to use my practice of law to be able to really work with communities and entities and to help enhance a lot of that work for small businesses and businesses owned by women and people of color. And I did a little bit of advising around securities and crowdfunding. And I was doing research for one of our clients who was interested in raising capital from its supporters. And I was super interested. I'm like, wow, this is so powerful. I want to learn more. And so when I started my own practice, I started to tell these businesses who were struggling with, sustaining their businesses. And I'm talking about, catering companies and just people who are really, really talented artists and just didn't have the ability or the capacity to go beyond a certain point. And so that's where it started, really to help the founder, the small business owner, those who are traditionally left out of the funding mechanisms of traditional banking, venture capital, et cetera. Now, though, I've come across people who want to, there's different strategies. They have VC funding, they have grants, and how do we put all this together, right? Mm-hmm. So part of my work is the compliance.
So, yeah, I'm curious by the politics of this. So I think the rule changes to the Jobs Act passed the House 406-4. So remarkable kind of bipartisan cooperation in a time where this country is like highly polarized. But what is the political opposition to these changes? Like when you say Biden kind of administration freezing the rules, is there a chance that one party or another might not be as excited about these rules, and if so, why?
That's interesting that you're talking about the House and the Congress. I actually took it as the new administration coming in and sort of checking with the old administration. When I mean administration, I mean the president, his quarters, right? So right. The agencies are under his tutelage, right? The federal agencies are the executive party. And I just saw it as he's coming in and sort of cleaning house of Trump's administration. That's the way out. So it is politics behind it. I definitely saw that, but I saw it more so the president coming in for his own agency to say, okay, either new hirees, right? So now changing chairmen or chairwomen, and then also saying, okay, let's check their work. I don't know. That's the way I saw it. Like they didn't trust it.
I think the reason why there has been bipartisan support for the Jobs Act in the past and updates to the regulations has been, for me, it appeals on both sides. Like on the Republican side, it's kind of, like free markets and people should be able to invest. If they can go to Las Vegas and invest or, bet on a roulette table, then why can't they invest in their local small business? It's being easier for entrepreneurs to raise capital. Mm-hmm. But then on the Democratic side, like right now, women-only founding teams get less than 3% of venture capital, compared to 80% for male-only founding teams. Like Black founders are getting 1% of venture capital. Almost 80% of VC is going to 3 states: California, New York, Massachusetts. So just from a kind of equity and leveling the playing field for underrepresented founders, and also enabling more investors of color or women investors to participate, even if they're not accredited. I would have thought it would be like, and I think it historically has been quite popular on both sides of the aisle. But do you know, are there kind of arguments either that the Republicans might put out or the Democrats as to why regulation crowdfunding might not be something we want to double down and invest in?
I can think about California to respond to that, because it's funny that you say California, Massachusetts, and New York are the 3 largest states that you will see a lot of these capital raises happening. And I think the reason why California is up there is because California is a very large state. But the state regulatory body actually is more conservative. even though it's liberal, right? The issue, though, the reason behind it is that they're protecting the investors. So unlike New York City, which is laissez-faire, and if you look at their actual securities law statute, it really is sort of more free than a lot of other markets. And so California is more restrictive, but there's more. So the people of California are more into crowdfunding, right? It's like this liberal, people from your Main Street should be able to invest, but this actual governing body or the legislator is a little more conservative. So I do feel like it's this push and pull between what the culture wants and the people actually wants, and then the sort of conservative governance.
And do you share those concerns around investor protection, and what's your perspective on how those concerns might be mitigated or addressed?
I don't necessarily share concerns about protections per se. As an attorney, though, I have seen that without legal representation, those are issuers who don't go in with sort of proper legal support. It does make me wonder, or make me sort of caution a little about, are they disclosing properly, or are they abiding by their responsibilities for risk factors and disclosing those, and et cetera? Because I have seen some that just, when it came to me and they were already had an offer up, I'm like, oh my, you put this up, but you didn't list X, Y, Z, right? Or you didn't disclose these certain factors. And so I am a little concerned with that. And the reason why I am concerned with it is because these are non-professional investors, so to speak, right? These are people who are maybe investing for the first time, and their expectations are necessary to manage. So now, you have people like, oh yeah, this was popular and I want to invest. Where's my money? Like a month later, right? And it's like, this is not how it works. So I think a lot of education needs to be had, whether it's from the SEC or just from the community in general, right? Whether it's from the portals, the attorneys, the marketers, people just need to communicate what this is for people. That would help. That would make me feel even better about it. But I don't mind. I mean, I'm only one person. I can educate, but it's still a whole industry out there that people are going in not aware of. So I will say, in that respect, just letting people know what exactly they're getting themselves into. What does it mean to be an investor in this space, or in the private market space, particularly? What does it mean when you're holding it for a certain period of time before you can actually even resell, right? If you want it, and then can you resell, right? There isn't this sort of secondary market in the private. I mean, again, these conversations are happening, but these are just realities of what people are getting themselves into. So not necessarily the protection per se, but although I do share some of that when I do see people go in thinking they're not really equipped in terms of they're not hiring the appropriate technical support providers to help them with their offer, particularly legal, right? And again, not knowing why they need a lawyer, right? Why is lawyers necessary when I have this template, right? Not realizing that it is so much more to it, so much more intricate. But for the most part, I think, like I said, I think it's one of the most democratizing capital raising mechanisms that there could be. Do it have limitations? For sure. And I mentioned them earlier, particularly for women and people of color, because it's within an industry or within a broader economic framework that I don't think itself can solve. In other words, generational wealth, right? It is what it is. Like, if people don't have it, crowdfunding is not going to solve it. We just have to go above and beyond to figure out how can people get access to crowdfunding with the upfront cost being there, right? So that's just one example. But I do, despite that, I think it is still one of the more democratizing, again, aspects of capital raising.
Yeah, you mentioned a couple of good points on like the upfront costs that are involved, and then also investor education. Can you talk a little bit more about the other law changes that affect like somebody who wants to start around post March 15th, and also who can invest and what they need to be aware of when deciding to make that investment and how much?
Yeah, so before we were talking specifically about regulation crowdfunding, Reg CF, there were limitations on both accredited and non-accredited investors. So accredited defined as, individuals, talk about individuals who make over $200,000 per year or $1 million in net worth, excluding their home, and obviously everyone else are non-accredited. That's outside of that category. And so with accredited investors, with regulation crowdfunding, there was a cap that was put up on those investors, and per platform, or not, I should say per platform, for entirely the Reg CF sort of regime. So for instance, if I'm a accredited investor and I want to invest in, company A on platform B, I only can invest up to $2,500 of the dollars that I have into the platform, and that was it. I couldn't kind of shop around and put another 25, another 20. Now with the new rules, as a credit investor, there aren't any limitations. I can put as much dollars to as many platforms as I want within any year, right? For non-accredited investors, the restrictions were, okay, we're not going to put actual number limitation or dollar limitation, but we will say that it's the least of your net percentage of your net income or your assets or net worth. Now it's flipped where it's the greater of, right? So they're going to look at the greater of your net worth or your income. So it helps, right? It increases one's ability, both non-accredited and accredited, to actually partake in this as real investors, as respectable investors, and so give them some type of return in exchange for their dollars. That's one. Did I answer your question?
Yeah, absolutely. And then what are the changes for a company that's coming to the platform? Like what, or any platform really, what do they need to get in order before they can actually launch a fundraise post March 15th?
Oh, like it's preparing to launch an offer. Oh, okay.
That answered my question 100%. I'm sort of now flipping to the other side of, like, what is testing the waters? Why is that important or why does that matter for a founder who's now considering Reg CF?
Right. Okay. So in addition to the investment dollar cap increases, so again, going from 5 million to 10 million, we also have, as you mentioned, Katie, testing the waters doctrine, which has always been a sort of aspect of Regulation A. Regulation A is another investment crowdfunding exemption, except that there aren't as many limitations or restrictions on advertising or general solicitation, and you can raise up to 50 million, but soon to be 75 million March 15th. So that is some of the additional investment caps for that particular exemption. So with testing the waters, Reg A was always able to utilize it. And basically testing the waters is an act of engaging the public through advertising, through general solicitation without, and I should say solicitation because you're not really soliciting anything. You're basically just putting up, hey, a filler for your community. I'm going to do an offer or a raise, and I'm thinking about, maybe this much, but I don't know, just kind of get a feel, will you invest in my company? And people are like, yeah, I will, or no, I won't, or maybe you should change this, or maybe you should add that, to your company, and then I will, right? And then it gave them, or the business issuer, the opportunity to sort of test it before they actually said, really put out an offer. Now, there were disclaimers, right? They couldn't accept any monies. They had to put the disclaimer on whatever their offering materials were to say, this is not an actual offer. This is just basically, again, purely for testing purposes. Now with the new rules, testing the waters is applied across the board for all exemptions under the Securities Act. And that includes Rule 506C, B, A, Reg A, 504, Reg CF. But the difference now, though, with the testing the waters is that prior to, because it only really particularly applied for Reg A and then also IPOs, you obviously was doing a Reg A, right? And you could state that I'm doing this for a Reg A. Whereas now you have to generically solicit or generically advertise, basically meaning you can tell the public that you're doing an offer, but you cannot tell them what this offer may be for. And honestly, it's designed for people who may not even know, right? They just kind of get a feel of what they could do. So for instance, you may not know that you can raise $1 million, or maybe you could raise 50. So you don't know if you're going to do Reg CF or Reg A, but you want to kind of get a feel what the public would do and how they respond. And so you're just basically asking the public, will you invest in my company? Oh, okay. Well, if you would, how much would you actually invest in? What's your minimum? What's your maximum? Kind of those type of questions. And again, allowing the business issuer to get feedback from the community or the public about their particular company and about, again, a little bit about their offers as well. But so that's the difference.
And can you talk about the terms? Like, could you say, we're thinking about conducting a campaign with, safe at a 5 million valuation cap, breaking $500,000 or?
Yeah, so they do allow for the terms to be stated, which in the way they define terms is amount of securities, the nature of the security, and the price. But you have to, again, those disclaimers have to be there, right, to state that I'm not accepting any money. Any money that you do send to me will be returned, just to make it clear that there isn't an actual offer happening. But you can get somewhat specific in terms of what it is that you're raising capital for your business, as well as how much are you thinking about. But you can't, with the new rules too, you probably want to be careful with how you're stating that, because you don't want it to lean towards as if you're leaning towards one particular exemption or the other. In other words, if you are thinking about an actual dollar amount, maybe be careful about you stating it so that it doesn't look like you're leaning towards Reg CF, right? Again, it should be generic about, just kind of get a gauge of what the public, how they deem your company and your offer, your potential offer.
What do you think, or how do you think this will change the landscape of founders who are choosing to start regulation crowdfunding campaigns now that they can basically just set it up and start to literally test the waters before they decide to dive in and do some of the compliance work involved?
It would definitely make people more confident, again, going to the conversation about the hurdles and the costs, right? It allows them to, to really think critically about what they want to do before they go out and do it, and also allow them to save money in case they decide, oh, this is not the right time. And I say but because there is this, and we talk about integration, right? And that's another change in the new rules. You still want to make sure that the materials that you're putting out as you're testing the waters cannot be construed as solicitation materials for an actual offer. And what that means is if you're doing a generic advertising, say, hey, would you invest in my company, so to speak, and not mentioning any type of offer. But then later on, you do conduct, for instance, a Rule 506B, which is a private offer. You want to make sure that whoever's coming to that those investors are coming to that offer, you had a pre-existing relationship with, right? So in other words, showing that generic sort of material to kind of test didn't result in this person coming to you that you didn't know, right, in this private offer. So it's like those, you still want to hire an attorney once you do decide to conduct an offer, because you want to make sure that they're not blending, your testing the water materials is not blending in with the actual offering materials or solicitation, to be on the safe side, so that it isn't this integration and this violation of the SEC rules. But yeah, I think people will take advantage. I think they should take advantage of it. And it does differ from demo day. We want to talk about that because it is kind of similar, but demo day is like more of a controlled environment. If you think about pitch competitions, if you think about, and a lot of people are familiar with pitch competitions, there's a room for the investors and business issuers and maybe a host. And the issuers or the small business or the founders are saying, hey, I want to raise capital for my business. This is what my business is about. Here's the debt. Here's how much I'm raising. There's restrictions on that, though, is that under the new rules, or prior to the new rules, you couldn't do that in Reg CF. You couldn't do pitch competitions. You couldn't do decks, because it goes against, again, this rule against advertising outside of the platform and just advertising or soliciting without having a qualified offer prior to. I'm sorry. Go ahead. Am I going on and on?
No. Yeah, I just want to clarify that. So if you, in today's world, if you were to have a campaign up and running on WeFunder or any platform, you could not say to the crowd in your demo day or in the Q&A section or anything, you couldn't say, I have an offering on WeFunder, please check it out after. You would have to completely wait, or how would that be structured versus how will it be in the new world?
No, I mean, if you have an offer that is existing, that has been qualified by SEC and is on WeFunder, you are limited in terms of your advertising of that as existing ongoing offer, which is, again, like you just stated, you tell people, hey, I have an offer. You actually can even describe the terms. So going back to the how much you're raising, what is the minimum investment amount, you just have to say, okay, this is fine and dandy, but click this link to WeFunder and actually invest, right? So you have there, and it's a notice. And right now it's written. So it's interesting because we have Clubhouse and people are all talking about or may say, hey, I'm raising money on WeFunder. I don't know if that's okay or not because this is all new, but the rules are supposed to be, it writes it as if it's a written notification to say, hey, here's a link, click here, go to WeFunder. Because imagine this being online on these platforms, right? Not sort of this on the phone or, these digital or audio aspect. But that's different from demo day. So demo day is now saying, prior to you, registering with WeFunder, prior to you filing with the SEC and getting qualified to go ahead and start receiving money, demo day is saying, here's how you can sort of advertise your offer. But that's interesting because now I'm thinking about the logistics behind that. Because if their intent is to receive money, then yeah, you would have to go through the qualification process. You probably would have to, have the platform already, your account ready to go. So the way I imagine actually going is a way for the investors or the businesses to sort of advertise to the platforms to show that I can bring a crowd, or to show that people are really interested in my investment. Hey, can I go on your platform and we can just get, basically that's when the transaction happened, right? So I imagine it being a twofold. Obviously, people who are going to invest are like, oh, this is cool. I love your deck. But then the platform is also like, I want you on my platform to get this happening, right? Because it is still that legal requirement. It didn't change. The new rules doesn't change that aspect of making sure that you have a platform and you have already in mind when you file your Form C, right? And get it qualified by the SEC.
Got it. I guess we've talked a lot about why founders might want to use this, and obviously some of the changes coming March 15th, 5 million cap, testing the waters is going to be great news for founders. Makes regulation crowdfunding a lot more attractive. But are there any reasons why founders should not pursue this, or at least kind of concerns or some things that might want to think through before deciding to raise capital in this way?
Yeah, I think the cost is the cost and the strong legal obligation. I think people need to know exactly what they're getting themselves into, because and even on some of the clubhouses talks that I have been having, people who have successfully raised a lot of capital, they would also emphasize it's not a walk in the park. I think people see these success stories and they're like, oh, all you do is put an offer and people are going to come. Like, no, there's a full, if you think about the Ben & Jerry's example, before Jobs Act of 2012, this is in 1984, the direct public offer, which is a state crowdfunding regime or scheme, right? Ben & Jerry had a brick and mortar, already had a business going, already had customers. And what they wanted was to raise capital from their customers and their neighbors to buy another building or something like that. And they raised $750,000. If you think about that culture, what that really was about was that they utilized a crowd they already had. They had customers, they had clients, they had neighbors, people walk by. It's this community. Now that we're online, it's still the same thing. It's just you have to change how you're approaching people because we're not physically present. And I think that people need to really know this crowd building phase. It's not just you putting something up. People want to know that you're already here in some way. Now, does that mean that you need to have revenues and a business going? I don't think so. But I do think you need a community and people who know you and what you're trying to do and why you're doing it. Maybe there's a purpose behind it, a mission, and you're doing things or posting things and related to that mission. That, to me, is something that needs to be emphasized and put to the people that are interested in crowdfunding, but also the costs that associated with it. Some people pay for marketing. I don't think, whether it's actual financial costs or your labor, either way, there's a cost to get the crowd going. And then again, the legal, right? Hiring an attorney that will help you not only just with the compliance. I personally help with a lot of the strategizing behind, again, how to couple these dollars, how to find these dollars. Not necessarily like, oh, I know I'm connected with investors. I'm not doing that per se. But what I'm saying is, oh, have you considered rewards? Have you considered equity? Have you considered combining the grants that you may have received? And whatever the case is, just thinking strategically about what's already in store. And I sometimes go through a crowd inventory as well. Sometimes you don't know who's in your circle that will support you to kind of say, okay, here are the people that will come for you and actually convert to investors, right? So that's what I think. If people aren't ready for that and they're looking for something quick, easy, and fast, with these, sort of outliers that are happening, that people are getting millions of dollars in a week's time, I don't think it's for you. Not to, again, the sky's the limit, and I'm not going to say that anyone should, it may happen for you, but for the most part, it's not likely to happen for you that way. So you need to definitely know that you're going to put in some work, maybe 6 months before you actually launch, right? About 6 months time frame. And pay money. Yeah.
Right. No, those are all great. We definitely want to be setting expectations with founders that it isn't a silver bullet. Fundraising is hard, whatever route that you decide to go, and aspects of regulation crowdfunding can be easier, especially like you mentioned, if you already have that community. But if you don't, and you still need to build that up before you're going to put this offering out there, then it's going to take a little bit more time. I guess more broadly, what advice would you have for someone who's considering launching a regulation crowdfunding campaign after March 15th?
please hire an attorney. I have to emphasize that. And I know it sounds self-serving because I'm a lawyer. I know. but realistically.
And please make it be me.
I'm accepting clients. No, but this is really why. One, I am an attorney and I look at things from a legal standpoint and I'm like, oh, if you do it wrong, look what could happen. We always do, as attorneys, we look at what all could go wrong, right? So that's one. And what could go wrong is fines, disqualification. You probably couldn't, can do another raise after the fact. But then also when we think about this as a growing industry and we talk about, a lot of attention on the business owner and the founder, but we don't talk enough about the investors. We don't talk enough about, without them, this wouldn't be a thing, right? Without people actually believing in it and saying, this is what I want to do and put where I want to put my money, we wouldn't have an industry, right? And so I think we do need to start thinking, or not start, a lot of us do, we do need to really emphasize the legalities around it and the sort of legitimacy around these offers so that people can maintain and continue to make this a thing, right? Continue to go to the market and create this crowdfunding industry and market and probably make a secondary market. Now it's growing, right? But because people believe it, instead of, we people do it, we have people doing it wrong, maybe don't have the proper risk disclosures. And then now people say, well, you didn't tell me this and I didn't know that. And, oh, this is a fraud or this is a scam or I felt cheated. You don't want people, it's like customer service. You don't want people to feel that way. Even if you feel that you did tell them, they didn't listen when you explained, right? It's still, you want to be able to really cross all your T's and dot your I's because it is a bigger industry outside of yourself that you may want to come back and do another offer. And then others coming from back, behind you that are like, I want to do this. And it's, again, a new way of raising business capital, whereas before was limited to a small few of people, right? The wealthier individuals. So that's my just I guess on that note, maybe to end on, we're in the early innings of this new way of raising capital, right? Jobs Act passed in 2012, rolled out by the SEC, Reg CF in May 2016. So, we're just updating the regulations, improving them 5 years in, but, hopefully in the very early innings of the ball game here. So if you can kind of paint a vision, like where would you love this regulation crowdfunding, investment crowdfunding to go over the coming, decades? What's your vision for how this might, shape the landscape of American, I guess, entrepreneurialism? Yeah, good question, Jonny. I would love to see regulation crowdfunding to be more racially diverse, gender diverse. What I don't want to see is just being another depository for wealthy white men to get more wealthy, right? And I say that because there's a trend from a VC to go into this world, and we know how VC looks. With statistics, I'm not making this up. It's homogenous, right? So what I would like to see though is this truly be an alternative for people who are just left out. Like I said, women, people of color, and then others. I mean, I've seen people come to me in other countries, like, how do I get into the American market? Of course, there's a legal way of doing that, and you have to make sure we do that. But people are really honing in, and people all over the world want to get involved. So let's just make it friendly for everyone, right? Let's make it where it's not these barriers or these gatekeepers, and people are feeling like it's not for me. Because, that doesn't represent America, right? It doesn't represent who actually are here and building this country from the ground up and living every day, right? So, yeah.
For sure. Yeah, well, thank you so much. Your perspective and your advice has been super helpful. Where can people contact you if they want to ask further questions or ping you for services?
Yeah, for sure. Thank you, Katie.
We got you, Elizabeth.
We got you.
What's
accepting clients.
Right. You can find me on all social media, and I mean Twitter. I shouldn't say all because I'm not on Pinterest, but Twitter, LinkedIn, and Instagram is ESQ LLC. Yeah, that's it. And then my email address is ec@elcesq.com.
Awesome. Cool. Well, appreciate your time. We're excited to stay in touch as the industry grows. Jonny, you have anything else to say?
I don't think so. It's been really informative and super fun. So thanks so much, Elizabeth. We'll speak soon.
Likewise. Thank you both.
Bye.
Bye-bye.
Thank you for tuning in to another episode of Adventure Capital. I hope you laughed, took notes, shed a tear, and most importantly, feel ready to go off on your own adventure. And remember, whenever you are ready, WeFunder is here to help.